think this is a landmark judgment from the High Court, which for the first time in the
mohon juga kepada pihak kerajaan supaya mengambil tindakan dan melihat balik dan supaya
Hi, my name is Amirrul Hidayat Binti Tubani. So today, my friend and I would like to present about our assignment, which is the analyzing a court case. Malaysia Airline Berhad, as known as MAS, is an Malaysia airline, and the claimant Ismail Nasaruddin was one of the employees in MAS. He served the company from 1989 to 2013. At the same time, in 2013, the claimant was appointed as president of NUFAM. NUFAM is a national union for flight attendant Malaysia, whereby it represents the cabin crew in Malaysia. The dispute commenced when the claimant had made press release pertaining to the company. When the statement comes to the company attention, the company issued the show cause letter to the claimant for 2 allegations. The first allegation was regarding to the claimant who insisted the CEO of the company, Encik Jauhari Yahya, where at that time he failed to solve the cabin crew problems. The second allegation issued by the company is due to the allegation or execution by the claimant to the company. The claimant claimed that the company has neglected and overlooked the employees' safety and welfare. The claimant said that the cabin crew employees at that time were demoralized because the company has cut the cost for the salary increment. Well, besides, they also face fatigue because of the busy schedule of the work. The claimant also stated that the company has changed the term in collective agreement with the in-house union, MASEU. The claimant replied the show cause letter stating that all the statements were made in the capacity of the president union, not as the employee of the company. The company did not satisfy with the explanation and dismissed the claimant on 29 November 2013.
Hi, my name is Nurul Syazwani Binti Ahmad Marzuki. I will be explaining to you about the issue that has been brought up to the court in year 2014. And Salihah will proceed with the year 2019. So basically, the main issue as been stated by Amirrul is whether the dismissal of Ismail Nasaruddin is considered with just cause and excuse. So the issue about the dismissal arose because the claimant actually stated that he was actually exercising his right as the president, NUFAM, exercising his duties and responsibility, but then the MAS terminated him, stating that he was actually the employee first before being a union. Okay, now to look whether the decision of the court made in year 2014 was valid or not relating to the dismissal, we would like to take in all the related provisions and acts relating to this employee-employer relationship. So, of course, we are looking into the Industrial Relation Act, Trade Union Act, Contracts Act, Collective Agreement, and all. So, first, we will look at Section 4 of the Industrial Relation Act, where it stated that an employer should not prohibit an employee from joining, creating, and even exercising his rights and duties as a union. So basically, Mas never did that. Mas did allow employee to join the union. This is obvious that Mas did not prohibit the employee from joining union, because at Mas itself has Masyu, and Ismail Nasaruddin himself is the president of Nufam. So, we look at Section 5 of the Industrial Relation Act, whereby it prohibits the employer from threatening, from discriminating employee who join the union, who do exercising his right as a union, whether or not he actually been challenged to the employer. So basically, this is where the issue rises, because Ismail Nasaruddin stated that Mas actually trying to union busting him when he made the press release. Okay, the second claim made by Ismail Nasaruddin justifying that his dismissal was unfair is because the president of Masyu also made the same press release calling for the resignation of the CEO, but then he was not being taken any action. Only Ismail Nasaruddin have been dismissed. So basically, Ismail Nasaruddin believes this is actually a discrimination made by Mas towards him. However, the court decided, based on the case Ranjit Kaur and Hotel Excelsior, whereby regardless of the company does not take any action towards the other party who made the same offence, it does not absolve that the claimant had actually made a misconduct and render the company's decision null and void. Lastly, I will be explaining to you about the trade union that involved in this article in 2014. It is relating to the liability in tort. So basically, Section 22 of the Trade Union Act stated that any tortious act made by a union member shall not be entertained in any court, and the Learned Counsel strongly believes that the press release was actually a tortious act, and hence this shows that Ismail Nasaruddin have absolute immunity and the case shall not be brought to the court. However, Mas stated that they actually dismissed on the cause of he actually made misconduct and not tortious act. So I will pass to Salihah. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. I Siti Binti Nasaruddin. I will present about the provision that had been discussed in 2019 and also the compare and comparison. After the industrial court has been awarded Ismail Nasaruddin to be dismissed from Mas, he take another initiative by decided to have a judicial review to High Court, and High Court award that the dismissal by the Mas to the Ismail Nasaruddin is unlawful and unfair. Thus, High Court of Kuala Lumpur decided that Mas need to pay compensation in lieu of reinstatement and back wage. This case became a landmark case, as this is the first time High Court had decided it was unlawful for a company to dismiss a trade union leader of issuing press statement in the course of the duty and the leader of the trade union. In Article 5, it talks about the right to liberty and security, which it explained about all people have the right to livelihood, right to privacy and quality of life. Ismail Nasaruddin claimed that it is his right to have this occupation and it is his right to conduct his duty as a president of NUFAM. The next one is Article 8 of Federal Constitution, which talk about the discrimination or equality. In this article, it is talk about all people need to be treated equally without any discrimination. Thus, Ismail Nasaruddin had claimed that he had been discriminated by MAS because of his position as a president of NUFAM. And after we analyze this article, it is not suitable for Ismail Nasaruddin use these two articles in this situation. And besides, these two articles, it is not been further discussed in the case. There are 3 cases that have been referred by the Industrial Court in settling this case. The first one is Wong Yuan Hock and Ahmad Kamaruzaman Azizan, where this case, it is talk about the reduction in award of back wage due to the claimant own conduct. In this case, Ismail Nasaruddin had admitted that he acknowledged the collective agreement that said it is unlawful for him as an employee to make a press statement to the media. So it is actually the court has the power to reduce the back wage due to his contributory act. The next case is Glasspack M. Sender Berhad and Seldom Pacific Sender Berhad, which talk about the pertaining company that insolvent to pay compensation to the employee. In this case, MAS had been changed the operation to the MAB, so the MAS itself it is not operated anymore. Also, MAS is facing the liquidation. Thus, MAS do not have money to pay the remedy to the Ismail Nasaruddin. The last case is IK Video Distributor Sender Berhad, which talk about rescaling compensation due to the post-dismissal earning. Okay, Ismail Nasaruddin it is proved that he had earned some money after his dismissal by MAS. Thus, the court had decided that he will face a reduction in back wage due to the post-dismissal earning. The first one is dismissal. Section 20 of IRA stated that the employee can bring the case to Director General if he found that he had been dismissed unfairly by the company. So in this case, Ismail Nasaruddin had bring this case to the Director General and the case been taken in the Industrial Court. So the second one, if the employer found that the employee had made a misconduct, there is no condemnation. Condemnation means the employer need to make a show cause letter or DI process the right after the employer found that the employee had made the misconduct. In this case, MAS had sent the show cause letter to Ismail Nasaruddin the right after 4 days of his press statement to the media. And the last one is Section 21A, which is stated that the case only can be heard if the case bring to the Director General within 60 days after the date of dismissal. So in this case, yes, it is within the scope of 60 days. Okay, the next one I will talk about the domestic inquiry, which is an internal trial made by the company to identify whether the accused person is not guilty or not because of misconduct. So what we have studied, it is compulsory for every company to make the domestic inquiry before dismiss the employee. We all know there's the domestic inquiry will start from the accusation and then to the show cause letter. After that, to the employee can reply the show cause letter and then appoint the committee of the domestic inquiry, and then the domestic inquiry will happen. But in this case, the process just stopped until the show cause letter to the employee. Why? It is because that after the MAS had sent the show cause letter to the Ismail Nasaruddin, after 4 days after that, Ismail Nasaruddin had admitted that he acknowledged all the collective agreement that had been said that it is unlawful for the MAS employee to make a press statement to the media. The court decided that it is not compulsory for the company to make a domestic inquiry if the company had found the strong evidence to prove the misconduct of Ismail Nasaruddin. Okay, the last one, I will talk about the collective agreement. As we all know, a collective agreement is a written agreement between the employer or the trade union of employer and the trade union of employee. After collective bargaining had been made and collective agreement had been written, the written document need to send to the industrial court before the collective agreement will be amended. The terms and conditions that have been proved by the industrial court, thus all the terms and the condition will be binding to both parties, and the court have the power to award these two parties. So in this case, Ismail Nasaruddin had breached two collective agreements. So what we talked about just now, the industrial court have the power to award the employee if the employee breached this collective agreement. That's all from me. Thank you.
After we had analysed the case of the President of National Union, Ismail Nasaruddin, and the Malaysia Airlines Berhad, we are humbled to give 3 recommendations relating to the issue so that if it is to happen again involving other company, it could be minimized, the loss and the time. So firstly, it's relating to the gap that exists between the in-house union, the company and the national union. So we would like to suggest that whenever in-house union and the company would want to create a new collective agreement, the in-house union should actually make the national union acknowledge about the collective agreement before agreeing to it, before signing to it. This is because the national union bring greater voice and greater power, so they should not be disregarded in this issue. Our second recommendation will be relating to the action of the MAS itself. So we could see that MAS is actually taking too long time in order to solve the issue relating to the safety and welfare of the employee of MAS. So the issue of work schedule and the weight management laws in MAS had been brought up 3 years back before the issue been made on press release. So basically, if MAS could take shorter time and solve the issue more faster and more efficient, this issue will not be this big, you know. Our third and last recommendation will be relating to the section under the collective agreement in MAS. So basically, we would like to suggest that they have to actually revise back the collective agreement or the MAS Book of Discipline, as we strongly believe that the article prohibiting the employee and the union to actually make on the press release had actually quite contradict with the fundamental liberties that been laid out under the Federal Constitution, the freedom of speech. So we strongly believe that they should revise back the collective agreement made.
In conclusion, for our opinion, this case is quite unique because the case is brought until to the Court of Appeal, and there are so many provisions and law under Industrial Relations Act and Trade Union Act is used in this. To conclude, the Industrial Court decide that dismissal of the claimant is lawful. However, the High Court had overturned the decision and said that the dismissal of the claimant is unlawful. And in 2020, the Court of Appeal has decided that the claimant dismissal is lawful. It is because the claimant, as the employee of the company, is bound to the company regulation. The Court of Appeal judge state that the claimant is bound with duties and responsibility for the company over the union. Thus, the statement made pertaining to the company is deemed for breaching the Book of Discipline and Collective Agreement.